Good morning, members of the board. Thank you, Mr. Chairman, for recognizing me. There is no question why I'm here before you today, and I know that the hour is long, and I have a lot of legal information that I want to give to you, so I'm going to go as fast as I can because we really would like to make sure that you have a chance to hear from the people here. But just so that we all know who we're talking about, if you are here in the audience in support of or against the annexation, please stand up to let your commissioners know that you're here. Now, the reason why these folks are here, thank you all. The reason why these folks are here, just like I am, is because I'm a parent of a student in South Fulton Schools who does not want her child's classrooms to be overcrowded. I'm a representative with direct knowledge of what the legal standard is for annexations. I'm a resident who, as a resident, I feel like if you want to go to another city, please go, as long as what the law requires. It does not hinder the residents of South Fulton County. But as a lawyer legislator, let me give you 9, not 1, but 9 legal reasons why you should deny this annexation petition. I'm going to refer you to the Georgia Code 363634, OCGA 363634. This is the code section that says someone must determine compliance to determine that these annexations are popular. And we received the email this morning from Commissioner Arrington, thank you very much for sending that out, in which the belief is that the county cannot legally do anything. But what this code section says is that whenever a governing body receives annexations, you are the receivers, that it shall, now Mr. Arrington's a lawyer and we all know in the law, shall and may are 2 different things. So it didn't give you an option. It says you shall, after an investigation. Now who does this investigation? Well, you all are the receivers. So you shall do an investigation to determine if the applications comply with the requirements. All right? So how many people who are here against the annexations have seen the results of any annexations by the Board of Commissioners? Raise your hand. So we still have an investigation that needs to be conducted. And what does that investigation have to include? Well, first it has to make sure that the maps as submitted complies with that 1/8 contiguity rule. Does anybody know if we've met that 1/8 rule? It also has to ensure that 60% of the electors, and the code section 3632 says that the governing body, that is you all as you know, must obtain a list of electors from the Board of Registrars. So if we have not done that today, it must be denied. It also says that 60% of the property owners. So you have to check to ensure that the petitions were submitted by property owners. That is just part of the investigation that has to be done by this commission before you can support this annexation effort. In addition to that, so those are 3 reasons. In addition to that, there has to be an application that complies with the rules, all right? The application has to include a plan and a report to talk about how the services will be turned over, to ensure that the harm of the folks does not occur as a result of this. This report has to include specifically a map of the municipality, a map of the adjacent territory showing the present and proposed boundaries, a map or maps of the municipality showing the present major trunk water mains, of the adjacent territory showing the same major trunk water mains and sewer inceptors. It must also show a map with proposed extensions of those mains and all of the things related to it. Now, even if that doesn't exist in the county, there has to be a report. And it has to be turned over. That is a requirement as a part of the investigation. And finally, a statement setting forth the plans for extending the area into municipal services. That plan has to be turned over. It has to be a part of the report. One of the things that has to be included in the report is how is the annexing city that's receiving the property going to keep up with the things you've already improved? For example, that lovely road work on Enon Road that came before this body that you improved for payment. Do you know, as you vote today, whether or not the city of Atlanta, if it receives that area, will continue with the work that was invested in there? That information comes from the investigation. So today I present to you on behalf of all the people who are here that this annexation petition cannot move forward legally today because we have not met the requirements of the plans, of the investigation, of verifying the information. Other more important things. The reason why all these people are here are not because of technicalities. They are here because if this annexation goes through, 1,850 elementary and middle school students will be uprooted from Sandtown Elementary and A. Philip Randolph. And they will be spread into all of the other South Fulton schools, one of which my child goes to. Overcrowding, change in bus transportation, and things that we are not prepared for. I had the honor to present to the Atlanta Public School Board meeting on Monday. And as I talked to some of our great school board members there, they had no clue what exactly we were talking about. They don't have a plan. Fulton County Schools doesn't have a plan. Who exactly is coming up with the plan for our children? And if there is not a plan, then this board must deny it. There is legislative intent, and you all know what that is. Just like when you all passed ordinances here, there was some discussion that led to where the ordinance came from and where it's going, and you can look at that to determine what was the intent. To say that the board has no duty, nothing you can do, why would they put in the legislative intent that it even has to come to you? To be a rubber stamp? Of course not. That was put there so that you can ensure that the petitions were valid, that it's contiguous, that there are actual voters. Now, the residents aren't sitting back and just waiting. They sat together and they poured through those petitions one by one. And Representative Bruce is going to go through those numbers with you to talk about specifically why those petitions aren't valid anyway. But don't take our word for it. What we're asking you to do is do the investigation that is required. And when you determine that it does not meet the 60%, not because we don't want the people who live in that area to go, we don't care about that. We are concerned about our children. That I have nothing more to say.
Good morning.
Good morning.
She didn't leave much for me to say. She did a wonderful job, and I'm going to say something anyway. And it's kind of interesting as I look at the members of this board. You know, I was sitting out here and I was saying, God, Lee, I must be getting mighty old, because I remember working with your daddy on the city council. I remember working with your uncle when he was the police chief. And Ms. Darnell and I go way back to the 70s, I believe, with EOA. And so I've been at this a long time. And but this is the first time that I've seen so many people, children, that will be negatively impacted by a decision that this board and the city of Atlanta could potentially make. When you talk about 1,700 children being displaced, being forced out of their communities, having their schools taken away from them, that is huge. And we need to take that very, very seriously. Both of us, all of us, are involved in making laws. That's what we do. And laws are designed to help people, to try to put us in situations where we are improving our communities and making life better for people. This action is not helping anybody. It's hurting. It's hurting a lot of children. Our communities are going to be disrupted. Some of the actual subdivisions involved in this will be split. Some of the people living in that subdivision will live in one city and the other one will still be in an unincorporated Fulton County. And then if this continues and people are not allowed to decide their own future, you're going to have subdivisions in two different cities, the same subdivision split because of the way this map is drawn. As my colleague said a moment ago, if it was not intended for you to have a say in what's going on, then why are we here? Why did this come before this board of commissioners if you don't have any authority to do anything? You have the authority. The law requires that you get 60% of the registered voters and 60% of the landowners. According to, and I hope I'm saying this word, the demographer that looked at all of these numbers, you could tell I'm getting old, I got to put on glasses to see this. None of the areas that we are questioning today meet the requirement of the percent of registered voters. In the Sandtown community, they have 40.9%, according to this professional demographer. The Loch Lomond area has 50.9%, and the South Oak area has 56%. So just on that basis, and that basis alone, you have the authority to challenge this annexation because they have not met the minimum requirement, and you're responsible for making sure that they meet it. And if they don't, then you have a moral obligation and a legal obligation to deny it. And that is what we're hoping that you do. And again, I want to leave time for the others, so I'm going to stop. But I want you as members, and I know most of you, and I haven't met this young man, but I've met everybody else, and I know everybody else. I knew you when you were a baby, okay? You have an obligation, not only as members of this board, but as members of this community. You have children, some of you have children. All I ask is if your child was going to be as negatively impacted by what could potentially happen, what would you do? Thank you very much.
Mr. Chairman, with respect to the obligation to inspect and ensure that the signatures are legitimate and that they do in fact constitute 60% of the electors in the affected areas, that duty falls on the city of Atlanta, not Fulton County. Fulton County does not have an investigatory role or function as relates to annexations, but merely to determine land use issues. If in fact there are issues with the names, signatures, authenticity, the city of Atlanta is required by law to have a hearing, and at that time any elector may appear and object to the annexation. Any elector may also file a lawsuit to contest the process by which the signatures were gathered and the authenticity of the signatures. But the Fulton County does not have a role under Georgia law with respect to that. What the statute says is whenever the governing body of a municipal corporation, that would be the city of Atlanta, the county is not a municipal corporation, it's the county, receives an application pursuant to Code Section 3632, it shall, that is the city of Atlanta, after investigation, determine whether such application complies with the requirements of this article. If it's deemed, as chairman, members of the board, that it does not, then the annexation cannot go forward. But this body does not play a role in the investigation of or verification of the signatures.
So can you restate the two grounds I think you cited that forces the city to, for lack of a better description, self-investigate itself?
Yes.
Is it so you mentioned about a public hearing and
yes,
a possible lawsuit as well?
Yes, sir. The city of Atlanta has a legal obligation to ensure that the signatures are verified and that they are, in fact, the signatures of 60% of the electors. It doesn't have an option. It must verify. If those signatures are not present, they're not verified, then the annexation cannot go forward. The city is also obligated by law to have a public hearing at which citizens who object to the annexation on any ground may appear and state their objection.
And is this process required to be transparent?
Yes, sir, it's required to be open to the public, and the city must publish notice of their intent to hold the public hearing prior to the public hearing being held.
All right, so before I yield the floor to the other commissioners, so what's before us? What are the options in terms of the request for approval? We can either accept,
Sir.
we can either deny. So if we accept, what happens if we accept?
If the county finds no legal grounds to object, it will notify the city of that, and the next process would mean it would go back to the city for verification. If the county objects, then the matter would go to an arbitration panel to decide whether or not our objection is valid.
Right.
Or the county can take no action
Right.
Regarding this matter, and the law would move the annexation forward by operation of law.
So if we don't take action, or if we approve, it proceeds on, but if we object, it goes to an arbiter.
Yes, sir. Arbitration panel.
So an arbitration panel then decides yes or no.
Yes, sir.
And where does the citizens, where can they have their input in terms of expressing their grievance?
That process doesn't involve citizens. The process that involves citizens is when the city gets ready to, in fact, accept the signatures, because this is under the 60% method. They have to verify that 60% of the electors in that area have, in fact, signed the petition. So in the arbitration process, they would not have that role, but still, the city has to determine if those signatures are valid.
Okay. Thank you, Mr. Ware. So, Mr. Commissioner Arrington, Commissioner Darnell, Commissioner Ellis, and Commissioner, ladies and gentlemen, let us deliberate without any distraction. Thank you so much, Commissioner Arrington.
Mr. Ware, that code section that you just quoted, is that the OCGA 3634?
Yes, sir.
And that code section applies to a municipal corporation only?
It does.
And the county is not a municipal corporation?
It is not.
So that code section only applies to the city?
Yes, sir.
I am a resident of unincorporated South Fulton County. My daughter is in the 9th grade at Westlake High School. She just graduated from Sandtown Middle School last year. She was part of the West 8 program, which allowed her to take 2 classes while she was in the 8th grade at Sandtown at Westlake. My youngest 2 daughters attend Stonewall Tell Elementary. So I am directly affected by this annexation. And my children are directly affected by it. However, I take great exception to people, alleged leaders, coming down here trying to pit citizens against the Fulton County Commissioners. The law is very clear. The city has the responsibility for verifying those rolls. I feel sorry for the citizens who have been misled by these people. I feel sorry that the people have been misled to think that the county commission has the right to deny this petition. The law is very clear. The rights are with the municipal corporation. Number one, if there are people that don't like the law, like me, I don't like it. I don't want my daughter to go to Thorough High School. I am a graduate of the Atlanta public school system. I'm a proud graduate of the Atlanta public school system. But my daughter's at Westlake, and I like the program that she's in, and I want her to remain there. And I don't want Westlake to become overcrowded. But it is absolutely irresponsible for people to send out emails and tell people to come to the county commission. People, you guys need to get a lawyer. You need to get a lawyer that knows zoning and land use law, that can tell you the proper procedure to contest an annexation request. Now, if I take a standardized test and I use a pen instead of a pencil, I could have the answer right to every question. But because I used a pen, it won't accept any of my answers. You can come down here and say what you want to the county commissioners. The law is clear that the city has the obligation and the right. The county only has 3 ways in which it can object, and all 3 of those ways are based on the use of the land. The part of the application that was submitted says that the use of the land will remain the same. These are single-family homes that we're talking about. They're not going to change it to a cemetery. These single-family homes are going to remain single-family homes. So the use has not changed. As a result, the county does not have a valid legal objection. And if someone told you that they did, they misled you. They misled you.
Commissioner, ladies and gentlemen, we heard you from during the public comment period. We listened, and please allow us to deliberate. Commissioner Arrington.
Now, what I will say is, I'm going to fight it, and I'm going to be keeping track of it because it's going to affect me and my children. So I'm going to fight it because it's going to affect me. If you want to fight it, let's follow the proper procedures. If you have a problem with the annexation laws, then you need to email and call your state representatives and tell them to change the annexation laws. Fulton County did not make the annexation laws. The state representatives make the annexation laws. And apparently they're not even familiar with them because they think that the city's responsibility is the county's responsibility. If you have a problem with what's going on with this Atlanta annexation, number one, you need to do what you guys have already done. Review those petitions. Because guess what? If the numbers aren't right, you go to that hearing, you file an objection with the city of Atlanta, they have to recalculate the 60%. If the number of people, if that lady's name was on there and she didn't sign it and someone signed her name fraudulently, those numbers will come off and it will have to be recalculated and it will have to be refiled. And I'm willing to help fight it in any way, again, because it's going to affect my children. But as leaders, we need to unite people. We do not need to be trying to send people down here to make examples out of county commissioners because someone doesn't know how to read a law. Now, if you don't know how to read the law and you're a legislator, then that's trouble. 36-36-34 specifically states that it applies only to municipal corporations. Fulton County is not a municipal corporation. Now, if anyone wants help, I'm going to be posting all this information on my website explaining what the process is to validly protest and object to an annexation request. And if you don't, and further, I'm going to also be posting the information so you can contact your state representatives and let them know that you want the annexation law changed. Guess what? I think it should be changed too. I'm going to contact my state representative and let them know that law should be changed. The law should include the impact on counties and schools. The law should be changed so that the county can have the power to object other than land use reasons. But don't come in here and try to suggest that we don't care about children because you don't know the law and because you're quoting the wrong law and because the person, the city is responsible and you're trying to say the county is responsible for something that is clearly identified as a responsibility of the city. I take great exception to that, particularly because my children go there. Don't be fooled. Don't be fooled by these people that have an agenda. They are promoting and pushing their agenda at all costs, no matter what, no matter even if they have to say it's the county's responsibility instead of the city's responsibility. Don't be fooled. Go read the statute yourself. Go read the statute yourself and you will see what the statute says regarding the county's role, the reasons for county objections, and the role of the city in annexations. And after you read that law, the statute is OCGA 36-36.1-1 in sequence. After you read that law, then you will know that you need to go to your state legislators and ask them to change it so it can include all of those great reasons that you all listed why this annexation shouldn't go forward. I agree with probably 80 to 90% of all of the stuff that people said, except that it's the county's role or the county's responsibility. The county does not have a role or responsibility in that. Our role is strictly limited to the use reasons outlined in the statute.